Assalamualaikum and a very good morning to all of you. My name is Fakiha with my team, Sufyan and Hakim are going to present about the role of justice system in conflict impunity. In the context of international conflicts, the term impunity refers to the lack of accountability for serious crimes and human rights violations. The international justice system, including the International Criminal Court (ICC), aims to combat impunity by investigating, prosecuting, and sentencing perpetrators of the gravest international crimes. The system aims to provide justice and reparation for victims of the future atrocities, establish a historical record, and contribute to lasting peace and reconciliation. Challenges include state sovereignty, lack of political will, difficulty obtaining evidence, and non-universal participation in institutions like ICC. Overcoming impunity requires a multifaceted approach involving the justice system, diplomatic pressure, security sector reform, transitional justice mechanism, and addressing root causes of conflicts. International tribunals such as the ICC play a vital role in combating impunity and holding perpetrators of the most serious international crimes accountable. So these tribunals operate at the international level, complementing national justice system when they are unable or unwilling to prosecute such crimes. The International Criminal Court (ICC) mandate and jurisdiction. The ICC was established in 2002 by the Rome Statute, which gave it the jurisdiction to investigate and prosecute four core international crimes, which is genocide, crimes against humanity, war crimes, and the crimes of aggression. So the ICC can only exercise its jurisdiction over crimes committed on the territory of a state party to the Rome Statute or by a national of a state party. It acts as a court of last resort, stepping in when national justice system fail to address these serious international crimes. Let's see the case example in prosecution of war crimes in Darfur. In 2005, the UN Security Council referred to the situation in the Darfur region of Sudan to the ICC. So this allowed the ICC to investigate alleged war crimes, crimes against humanity, and genocide committed in the Darfur conflict since 2003. So the ICC issued arrest warrants for several high-level Sudanese officials, including President Omar al-Bashir, for their roles in the atrocities. However, Sudan has not cooperated with the ICC and al-Bashir remains at large, highlighting the challenges of enforcing arrest warrants against non-cooperative states. Despite these challenges, the ICC investigations and prosecutions efforts in Darfur have first contributed to the establishment of an authoritative record of the crimes committed, provided a platform for victims to have their voices heard, reinforced the international norms against the use of mass violence against civilians, and the ICC work in the Darfur case demonstrates both the potential impact the international tribunals in addressing impunity as well as the significant obstacles they face in enforcing their mandates, particularly against non-cooperating states. Overcoming such challenges remains a crucial task in strengthening the international justice system and upholding the accountability for the most serious international crimes. The International Criminal Tribunal for the former Yugoslavia (ICTY), the role in prosecuting war crimes in the Balkans. The ICTY was established in 1993 by the United Nations Security Council to prosecute war crimes, crimes against humanity, and genocide committed during the conflicts in Balkans in 1990s. Its jurisdiction covered the territory of the former Yugoslavia, including Serbia, Croatia, Bosnia, Herzegovina, Kosovo, Macedonia, and also Montenegro. So the ICTY played a crucial role in investigating and prosecuting the most senior political and military leaders responsible for the atrocities committed during the Balkans War. Its works helped to establish an authoritative historical record of the crimes, provided justice and reparations for the victims, and reinforced international norms against war crimes and crimes against humanity. Let's see the case example, the trial of Slobodan Milosevic, the former President of Serbia and President of the Federal Republic of Yugoslavia, was one of the most high-profile defendants tried by the ICTY. He was charged with a total of 66 counts of war crimes, crimes against humanity and genocide for his role in the conflicts in Bosnia, Croatia and Kosovo. Milosevic's trials began in 2002 and was the first time a former head of a state had been brought before an international criminal tribunal. So the trial was seen as a landmark in international justice, as it aimed to hold a senior political leader accountable for the atrocity committed under his command. However, the trial was cut short due to the Milosevic's death in 2006 before a verdict could be reached. Despite the premature end to the trial, the ICTY's prosecution of Milosevic was highly significant in establishing the principle of individual criminal responsibility for senior political and military leaders. The ICTYs worked in prosecuting war crimes in the Balkans, including the high-profile case of Slobodan Milosevic, demonstrates the critical role that international criminal tribunals can play in providing accountability and justice for victims of mass atrocities. While faced with challenges, such tribunals remain essential in combating impunity and upholding international norms. So, to be more comprehensive, let me pass the presentation to Sufyan.
Thank you so much, Ms. Fakiha, for that marvelous explanation. Moving forward, let us dive in depth in the understanding of these three case studies for our presentation. The first one would be the justification on Rwanda's Gacaca Court. The Gacaca Court were a community-based justice system that was established in Rwanda to deal with the massive backlog of genocide cases following the 1994 Rwanda genocide, where around 800,000 people were killed in a span of 100 days. The traditional Gacaca system was adapted to handle the overwhelming number of cases in a manner that aimed to achieve justice, reconciliation, and community healing. Some of the key characteristics for Gacaca Court will be as the following below. Number one would be efficiency in handling the caseload. After the genocide, the conventional justice system in Rwanda was overwhelmed with an estimated of 100,000 and 300,000 people detained on genocide-related charges. The traditional court system would have taken decades to process all the cases. The Gacaca Court significantly expedite these processes by handling approximately 1.9 million cases by the time they were closed in 2012. The second one would be community participation and ownership. Gacaca Court were rooted in Rwanda traditional conflict resolution methods, which emphasized community involvement. This approach fostered a sense of ownership and responsibility among Rwandans for the justice process, and the community members serve as judges, known as the Inyangumayago, and the participatory nature that courts encourage collective healing and reconciliation. The third one would be promoting reconciliation. The keyword would be reconciliation. The Gacaca process aimed to promote national unity and reconciliation by encouraging truth-telling and fostering dialogue between perpetrators and victims. Offenders were often required to publicly confess their crimes and seek forgiveness, which helped the restoration and relationships and the rebuilding of social trust. The fourth one would be restorative justice approach. Unlike any conventional retributive justice, which focuses on punishment, Gacaca Court emphasized restorative justice. The goal was not only to punish offenders but also to reintegrate them into society. This approach included community service and reparations as part of the sentences, which contributed to the rebuilding communities and the healing process. The fifth one would be cultural relevance and accessibility. By utilizing a traditional justice mechanism made by the Gacaca Court more culturally relevant and accessible to the Rwandan population. The informal setting of the Gacaca Court, often held outdoors, made it easier for people to attend and participate in the proceedings. Last one would be cost effectiveness. Given the limited resources available in post-genocide Rwanda, Gakaka Court provided a cost-effective and alternative to the former judicial system. The use of community judges and the informal setup reduced the financial burden of the state while still delivering justice. To conclude, despite these challenges, the Gakaka Court are widely regarded as having played as a crucial role in Rwanda recovery from the genocide. They provided a pragmatic solution to the enormous challenges of dealing with the aftermath and the mass atrocity. By balancing the need of justice with the goal on reconciliation and nation building, and by blend the traditional practices with modern objective, Rwanda's Gakaka Court offer a compelling example of how the localized justice mechanism can address these complex post-conflict realities. The second case study would be on the Special Jurisdiction for Peace in Colombia. The Special Jurisdiction for Peace is a cornerstone of the Colombian peace process that was established as part of the peace agreement between the Colombian government and the Revolutionary Armed Forces of Colombia, FARC, in 2016. The JEP is designed to address this crime committed during the decades-long armed conflict in Colombia, aiming to provide justice, truth, reparation, and guarantees of non-recurrence. The Special Jurisdiction for Peace is a pivotal element in Colombia's transitional justice system, designed to address the legacy of the armed conflict through a combination of retributive and restorative justice measures. By focusing on truth, reconciliation, and reparation, JEP aims to lay foundation for lasting peace and healing in Colombia. Despite facing significant challenges, the JEP represents a bold and innovative approach to post-conflict justice and reconciliation. Some of the objectives of JEP would be justice for victims. It provides accountability for serious crimes committed during the conflict, including war crimes and crimes against humanity. It also ensures that victims receive justice, reparation, and truth about the abuses they suffered. The second one will be truth and reconciliation. It facilitates the establishment of a comprehensive truth about the conflict that contributes to national reconciliation and healing. It also encourages perpetrators to confess their crimes in exchange for reduced sentences, thereby promoting restorative justice. Legal certainty and reintegration talks about the offer legal clarity and protection to former combatants who comply with the peace process, aiding their reintegration into society. It also ensures that those who fail to comply face appropriate and legal consequences. The third case study would be on South Africa's Truth and Reconciliation Commission, or known as TRC, and restorative justice. The TRC in South Africa is one of the most well-known examples of a restorative justice approach in a post-conflict setting. It was established in 1995. By following the end of apartheid, the TRC was designed to uncover the truth about human rights abuses that occurred between 1960 and 1994. It also promoted the national reconciliation and healed the nation. The TRC of South Africa is a landmark example of restorative justice in a post-conflict setting. By focusing on truth, acknowledgement, and reconciliation, this TRC sought to heal the wounds of apartheid and build a foundation for a more just and cohesive society. While not without its flaws, the TRC's emphasis on restorative principles over retributive justice has left a lasting legacy in the field of transitional justice and has provided valuable lessons for other nations that grapples with their own histories of conflict and human rights abuses. Some of the objectives of TRC would be truth-seeking. It established a comprehensive and official record of gross human rights violations committed during the apartheid era. And also it provides a platform for victims and perpetrators to tell their stories. The second one would be reconciliation and healings. It promotes reconciliation between victims and perpetrators and within the broader society. It also facilitates the healing of individuals and communities affected by the apartheid era violence. The third one would be restorative justice. It emphasizes restorative rather than retributive justice by focusing on repairing harm and restoring relationships. It also encourages perpetrators to acknowledge their wrongdoings and seek forgiveness. Lastly, recommendation and reparation and reforms is to ensure to make recommendation for reparations to victims and institutional reforms to prevent future abuses.
Thank you, Sufyan. Next, let's dive deeper into the international responses to humanitarian crisis in the context of the role of the justice system in conflict, with a special focus on impunity and its impact on international conflict management and conflict resolution. So, humanitarian crises often arising from armed conflicts, severe political instability, or natural disasters, which necessitates comprehensive and coordinated international responses. These responses are crucial for addressing immediate needs and laying the groundwork for long-term peace and stability. The justice system, both at national and international levels, plays an integral role in these efforts, seeking to hold perpetrators accountable and provide redress for victims. One significant example of international response is the establishment of the Independent International Commission of Inquiry on Syria by the United Nations Human Rights Council in 2011. The Commission's mandate is to investigate all alleged violations of international human rights law since March 2011 in Syria. Its primary roles include documenting violations, submitting detailed reports to the UN, raising global awareness, and advocating for accountability by recommending actions like referring cases to the International Criminal Court or ICC. However, the Commission faces numerous of challenges, often denied entry into Syria, which it relies on remote investigations which can limit the credibility of the evidence that they gather. So, next, the Syrian government's refusal to cooperate also further hampers its effectiveness. Additionally, geopolitical interests and vetoes by permanent members of the UN Security Council, UNSC, particularly Russia and China, blocked the referral of cases to the ICC. Last but not least, the security concerns also pose significant risks to witnesses and also investigators, which complicating the collection of reliance evidence. So another key aspect of international response is the role of United Nations peacekeeping missions. These missions aim to uphold human rights and combat impunity in conflict zones. They protect civilians, support the rebuilding of justice system, monitor and report human rights violations, and facilitate transitional justice mechanisms like through commissions and reparations programs, or POC, which sites that provides refuge to thousands of displaced persons, shielding them from violence. It supports the South Sudanese justice systems through initiatives like mobile courts, which bring judicial services to remote areas, addressing impunity for serious crimes, including sexual and gender-based violence. Furthermore, MIR provides training and resources to South Sudanese police, judiciary, and corrections personnel to enhance their capacity to uphold the rule of law. Its human rights divisions monitors and reports on human rights abuses, advocating for justice and accountability. So, in conclusion, for my point is, the justice system is vital for managing and resolving conflicts by upholding the rule of law, protecting human rights, and ensuring accountability. International responses to humanitarian crises, such as the Commission of Inquiry on Syria and the UN peacekeeping missions, illustrates the challenges and also efforts in addressing impunity. Strengthening this mechanism and enhancing international cooperation are crucial for combating impunity and achieving sustainable peace in conflict-affected regions. Our continued commitment to justice and human rights is essential for building a more peaceful and equitable world. So before we end our presentation today, let me conclude the overall points of our presentation. So, in conclusion, the multifaceted role of the justice system in addressing impunity within conflict zones emerged as a pivotal force in fostering accountability and securing enduring peace. The landscape of combating impunity spans across various arenas, from the jurisdiction of international tribunals like the International Criminal Court (ICC) and the intricate workings of domestic justice system, exemplified by Rwanda's Gacaca courts and Colombia's special jurisdiction for peace. These mechanisms serve as pillars in the relentless pursuit of justice, grappling with the complexities of holding perpetrators accountable for their actions. Moreover, the implementation of restorative justice approaches, epitomized by South Africa's Truth and Reconciliation Commissions, TRC, underscores the transformative power of reconciliation in the aftermath of conflict, paving the path for healing and societal cohesion. Despite formidable challenges and entrenched obstacles, international responses to humanitarian crises, epitomized by initiatives such as Independent International Commission of Inquiry on Syria and the tireless endeavors of United Nations peacekeeping missions, signal a collective resolve to confront impunity head-on. By amplifying the voices of the oppressed, safeguarding human rights, and championing the rule of law, these endeavors exemplify the global community's unwavering commitment to upholding justice and combating impunity in regions ravaged by conflict. It is within these concerted efforts that the seeds of sustainable peace are sown, offering a beacon of hope amidst the tumults of uncertainty and strife.